Hello again, and thank you for staying with us. Going to this conversation now, the Matjhabeng Local Municipality in the Free State has suffered a legal blow. Its appeal against a case brought by the DA has been dismissed by the Free State High Court in Bloemfontein. The DA argues that the Matjhabeng is in financial crisis and has been failing to provide basic services to its residents across towns like Welkom, Virginia, as well as Odendaalsrus. In November last year, the party called for intervention from both the provincial government as well as the Minister of Cooperative Governance. I am joined now by DA Member of Parliament, George Michalakis, to tell us more. George, good to have you on the program this evening. Firstly, let's begin with this recent court ruling. What does this judgment mean for the people of Matjhabeng and municipalities in similar situations across the country?
Good evening, Nhlahla, and good evening to the viewers. Yes, the case, I think, is quite important in the sense that it sets, firstly, a precedent in the Free State, at least, with regards to the obligation of the provincial executive to intervene in such municipalities where the financial situation is not sustainable, which ultimately leads to service delivery failure. In this specific instance, the court has ruled initially that the municipality and the province will now have to come up with a financial recovery plan, which they will have to file within 6 months, which will hopefully be the blueprint then for financial recovery for the municipality, because ultimately if we don't get the finances of this municipality set right and on the path to recovery, you will not have the municipal services that will follow. The municipality's finances is in such a state that obviously the services as a consequence is just non-existent in most instances.
Let's speak about that. The court has found no dispute in the DA's facts about Matjhabeng's failures. What made this case so strong, despite the municipality's appeal here?
So I think obviously the case is that the municipality and their finances completely is in complete ruins. It's clear for everyone to see. I don't think that either the provincial government, the national government, or the municipality could argue against that. I mean, the service delivery failure record is so clear that it can't be hidden and it can't be argued against it. It is quite strange that it had to require us to go to court to compel the provincial government to actually intervene, which is a constitutional obligation. And that was made quite clear. But to make it worse then, after they lost the case on that basis, they found it necessary to delay it even further, spent further tax money, and then to take it on appeal, which they, it never went to appeal. The application to appeal got dismissed. But the crux is that the financial failure is so evident that none of the three government spheres could actually argue against that. And it is quite curious that they thought that they should actually take this on in court and argue against it, instead of just getting on with what they're supposed to do.
But how significant is this ruling, especially in terms of enforcing Section 139 of the Constitution as well as the MFMA? Do you believe it will force a national shift in how failing municipalities are actually managed?
Well, I think it sets an important precedent. The normal interventions that we've seen are in terms of Section 139(1) of the Constitution. This one is in terms of Section 139(4) and 5. Which is a financial intervention. And the difference between the two in terms of the Constitution is that with regards to financial intervention, it puts an obligation on the provincial government to intervene. It's not just a discretionary obligation that they have. The Constitution says very clearly they must intervene. So that question was tested through this case. Obviously, it's a Free State High Court matter, but it does set an important precedent throughout the province and obviously throughout the country. It will hopefully have some impact, but within the Free State itself, obviously the precedent is now set to say to the Free State Provincial Executive, look, if there is a municipality in the province where they are clearly in default of section or of chapter 13 of the MFMA, then you as the provincial government have an obligation, not a choice, to intervene rather sooner than later and to make sure that the municipality sticks to proper financial discipline. This is important because up to now, a municipality like Matjhabeng has been left for decades to be run to a point of ruin without the provincial government lifting so much as a finger to actually intervene for the sake of the residents.
George, let's continue unpacking the findings. The audit exposed over 239 million rand in water losses and 339 million in wasteful expenditure. Why do you think these problems persisted for so long, especially without any intervention?
Well, I mean, I think the failure to intervene is clearly political. Also, some of the former mayors of that area ended up being MECs in Ace Magashule's cabinet and subsequent cabinets as well. So I do think that the failure to intervene is purely political on the part of the ANC in the Free State. Obviously, as you might think, if the money disappears, then there's less money for infrastructure, there's less money for service delivery. So it's going to take many years to actually get Matjhabeng itself fixed, which is the consequence. The service delivery failure at the moment is all due to the fact that the infrastructure is so old and so fragile that on a constant basis, people either have water shedding or no water at all. I heard today that for the first time in a few days, a town like Henneman has water again. So I do believe that the failure to intervene earlier in Matjhabeng's case is political. It doesn't help, though, I must say, to intervene in terms of the constitution and then you appoint the wrong people as administrators. It is now important that people who actually know what they're doing in terms of finance are appointed in these positions to be able to fix the municipality.
Some are arguing that there is a history. In your view, how much of Matjhabeng's crisis stems from inherited challenges versus current governance failures?
Well, I mean, the current mayor, who was for a long time suspended, was in the municipality cabinet mayoral committee for a very long time. I don't think they can currently claim that they've inherited this from previous administrations. I think it's a continuous thing, and I think it's something that has built on each other. I think as far back as about, what was it, two decades ago, there was the Fivers report that also found very serious maladministration, financial and administrative, within the municipality. And ever since then, it's just gotten worse and worse and worse. Without any intervention or accountability as far back as that. We're looking at 20 years of no accountability, failure to actually get the municipality right. And the names keep popping up. So it's not just a legacy inherited, but it's actually a system of people who get recycled and people who just get shifted into different positions. But I don't think most of them, at least the ones with the power, are in a position to say, well, we inherited this crisis. They are actually part of the crisis themselves.
But interesting, the municipality cites progress since the new administration took office back in 2021. Did the DA see any credible signs of recovery efforts before even pursuing legal action?
Oh, no, we didn't. Obviously, we had to make out a case to say that it's gotten worse and worse, and this we've done. The municipality tried to argue that let's delay it by 6 months and see what we can do on the basis of a new municipal manager who's been appointed. And the judge actually in the arguments asked their counsel, but what are you going to do in another 6 months? Because in the time that the new municipal manager as the accounting officer had been appointed, they virtually did nothing. I think they bought 1 or 2 vehicles with which they were planning on delivering services, and those vehicles were standing still at the time of the court case. So very little was done in the first few months of the appointment of the new municipal manager, and the court was not willing to give them an extra few months before granting this order. So, yeah, I do not think that without a court order forcing them to actually change direction, that this would have come from the municipality out of their or from their own accord. It had to be something that compelled them, which is sad because it's an indication of how much or how high on the priority list service delivery actually is.
George, as we start wrapping our conversation as well, I want to thank you for giving us your time. That's George from the Democratic Alliance.